Noted.
Just remember, I was the good kid that said that I could for at least till 2:30.
Hey, Chair, we are live, so ready when you are.
Thank you, Hunter. All right, I will call to order the July 24th, 2024 meeting of the Sentencing Commission's Misdemeanor Subcommittee. Good afternoon. Nice to see everyone this afternoon. And welcome to those who are viewing the meeting via the Department of Sentencing Policy's YouTube channel. This will be the third meeting of the 23-25 meeting cycle. I will now ask Director Powers to take the roll, please.
Thank you, Chair. John Arascata. Judge Bishop.
Present.
Christine Jones Brady.
Present.
James Conway. Judge Cruz.
Here.
Wes Duncan.
Here.
Jack Esslinger.
Jack let me know he wasn't going to be able to attend.
Perfect. Nick Graham.
Present.
Evelyn Grosnick. Eve Hanan.
Here.
Chief Higgins.
Present.
Dr. Lancherman.
Present.
Christina Mortensen. Lisa Mosley Sales.
Present.
Michael O'Brien. John Piro. Marcy Reba.
Present.
Elisa Schultz.
Lisa also let me know she wouldn't be able to attend. She's at a national conference.
Holly Wellborn.
Present.
Chair McCormick.
Present, and I think Mr. Arascata joined us as well.
I did see that. Perfect. Chair, we do have a quorum.
Thank you, Georgia. The next item on our agenda is item 2, which is the first period of public comment. There are 2 periods of public comment, one at the beginning of the meeting and one at the end. Members of the public have 2 options for submitting public comment. First, members of the public may do so in writing by emailing the Department of Sentencing Policy at their email address. Public comment received in writing will be provided to the commission and included by reference in the minutes of the meeting. Members of the public who wish to testify may also do so by telephone due to time constraints, Comment will be limited to 2 minutes. Any member of the public that exceeds 2 minutes may submit their comments in writing to the Department of Sentencing Policy. At this time, I will ask Ms. Jones to manage and direct those who wish to testify by telephone.
Thank you, Chair. Members of the public who would like to testify by phone, press *9 to raise your hand. When it's your turn to speak, please slowly state and spell your first and last name. And it looks like we have no callers who would like to participate.
Thank you, Ms. Jones. I would note that we did receive a written public comment from, I believe, Tanya Brown submitted it on behalf of a Mr. Michael Atkinson. So the commission has received that and has had an opportunity to review it, or the subcommittee rather. Excuse me. All right, with that, we will move on to our next agenda item, which is approval of the minutes from the last meeting we had on May 8th. Are there any comments, corrections, or edits to the minutes? Hearing none, I will entertain a motion to approve the minutes of the May 8th meeting.
So moved.
I have a motion from Chief Judge Higgins to approve the minutes. Do I have a second?
Second.
Sorry, didn't catch who seconded, but I had a second.
Cruz.
Thanks, Judge. Judge Cruz has seconded the motion. Is there any discussion? All in favor say aye, raise your hand. indicate in some way that it is acceptable. Anybody opposed? Hearing none, the motion passes, the minutes are approved. And now we will come to item, and Georgia, I would note John Pirro just joined us. I will move on to item 4, which is the sole agenda item we have today, and that is working group reports. As you recall, at the last meeting, we decided to break into a few working groups, and then each group would do a a homework assignment of identifying statutes they or misdemeanors they think may be meritorious of it may be meritorious to repeal those, excuse me, and then also identify the issues that they wanted to study and the data points that we're going to need to ask NDSP to collect. So, and we did have some submissions before the meeting. I believe Judge Higgins submitted some documents, and Jack Eislinger, knowing he wouldn't be here, also sent me an email with his thoughts, and I believe that's been provided to everybody. I'm hoping this will be a good discussion here. I didn't have a particular agenda in the way to move this forward. Because he was on task and did his homework, I might lean on Judge Higgins to make a few comments about what he supplied to get us started.
Well, Judge Cruz and I spent, was it several hours, Judge, on the phone going through the entire list of misdemeanors. It just seemed like several hours. And there's a lot of stuff in there that could be fixed. And I think there's a lot of stuff in there. There was a political or legislator, some legislator had something happen to them in 1953, and that's the reason there's a statute about it. But I think we got to take the priorities, I suppose. But I'll just buzz through the list real quick. There's several in the, of course, and this is purely self-serving, I suppose. There are several statutes in Chapter 4 that makes it a misdemeanor if we don't have open books at the courthouse, if I charge excess fees, if I purchase a judgment. I'm not even sure how I would go about purchasing a judgment. I guess that used to happen. So there's several there. Selling liquor at a religious meeting. There's several statutes on the sheriff failing to regulate houses of ill fame. I think there's several. There's a statute on advertising products to produce a miscarriage. I'm sure that was leftover 18th century anti-abortion stuff. Advertising cures of sexual disorders, reckless driving of a horse, Judge Cruz's favorite, failing to bail an animal appropriately. There are statutes on if you're on the public payphone and somebody comes up to you and says it's an emergency and you don't let them use the phone, it's a misdemeanor. And it's also a misdemeanor if the phone company doesn't put a notice of that in the telephone directory. And I couldn't even tell you where a payphone in Nevada is and when the last time I saw a phone directory. I must tell you, sadly, that I was in the long committee meeting that decided that the unsolicited transmission of fax advertising should be a misdemeanor. I was working at the AG's office at the time and listened to several hours. It's back when you had to pay 20 cents a fax, and somebody come back from some insurance guy had come back and there's 300 pages of advertising, and it irritated people. Of course, my real favorite is it's a misdemeanor if I fail to appear with the sheriff and disperse riots. It says the justice of the peace shall appear at a riot with the sheriff and disperse the riot, and if I fail to do so, it's a misdemeanor. So, not that it's happened lately, I suppose. Although, when we were having those little riots downtown, we had a little something across the street. And one I think gets violated fairly frequently is the sale, gift, or disposal of liquor within the Capitol building is a misdemeanor. So those were just some of the things that stuck out to me. Some of them are silly. I think most of those should be easily changed without much consternation. I'm sure other people have fuller lists and more thorough analysis. Thank you.
And there's another one we also had, I think that we talked about that it's worth taking a peek at is unlawful assembly underneath 203.060. That's the one that if you gather to talk about the crime and then you disperse without committing the crime, that's a misdemeanor.
Oh, okay.
And then we also talked about bringing non-resident indigent into county. Because we're not really sure if they're gonna start, how that's even policed, but it's a misdemeanor. That's 428.110. Those were just ones that we just said were worth a look.
I think a few of those were also on the list. I sort of tried to inflict on everyone at the last meeting as well. So, which I am trying to find now.
Here's the one that's about 2.5 pages long.
Yeah, mine was the 50 some odd item one. That, yeah, misdemeanors to repeal. That list was in the meeting packet from last time and included not only like if the group is amenable to suggesting that we repeal the misdemeanors for justices of the peace who purchase judgments, however that works, or failure to keep their books open to public inspection. I would think we may want to also look at, there's one in the Supreme Court that makes it a misdemeanor if Elizabeth charges non-authorized fees. Now that we're electronic, I don't know, that one may be unnecessary. And then a district judge cannot accept a gratuity for performing a marriage. So again, we have a number of those, but I would really be interested in hearing from other folks, other groups' perspectives on that. Or I can just talk. I mean, Oh, Ms. Jones Brady raised her hand.
I hate to be the Debbie Downer. So I'd like at least a conversation about the justices of the peace throughout Nevada, where there are many counties within Nevada where you don't have to be an attorney, dependent upon the population. And our office receives a lot of miscellaneous complaints coming from the rurals. So I'm not sure how some of the justices of the peace, they're not, if they're not an attorney, there's still some accountability for them, but it's not in the same way as like a Judge Higgins, where he's an attorney, and if he does something wrong, he's subject to, the bar review and the whole 9 yards. So I'd like a conversation about that, because at the AG's office, we get a lot of complaints coming in from rural and frontier areas of Nevada.
I would, on that, my thought is that once, regardless of whether or not they're attorney or non-attorney, once the judge assumes the judgeship, they're subject to the purview or the oversight of the Judicial Discipline Commission. I mean, in the event that, say, I'll pick on Judge Bishop instead of Judge Higgins this time. In the event that Judge Bishop did something horrible, he could be subject to discipline from obviously the Judicial Discipline Commission, then additionally the bar with relation to his license. So I'll throw that out there. And also, I mean, I think at this point, and maybe this is just my opinion, that if there are those concerns, do we spend the time now and hash it out? Do we return to it later? How does the group want to proceed? Because I think if my supposition may be, or is slightly correct, that everybody can have their list. We can parse them out, find the same ones, and make that easy as far as making that recommendation to the Sentencing Commission. But I'm thinking the group probably wants to talk a little bit more about the sort of the ones that they're puzzled by, confused by, want us to study more, and or the data that we should be trying to figure out if we can collect. Judge Bishop, you have your hand?
Has the bar ever disciplined a sitting judge that anybody's aware of?
I don't believe so. when we were working on the judicial discipline bill last session, that was a conversation because there's kind of a gray area on when attorneys are running for office. And judicial discipline contends they don't really want to deal with it. The bar contends they don't really want to deal with it. So there's some gray area there. I've been involved in this system for 18 or so years, and I don't recall bar discipline for a judge outside of judicial discipline. Judge Higgins?
I just point out that this all predated the audits we're all required to do. So the AOC audits us, I don't know, once or twice a year, and the books have to cash out. The county audits us once or twice a year. They count out every nickel. We've got the mandatory accounting standards, which is a binder. It's about 8 inches thick. Thank you, Mr. McCormick. That every nickel has to go into every category. I think all of this was like pre any kind of financial accountability. Some of them from the 1880s and 1860s. I want everybody to be fully responsible for everything, but I think it's covered a different way now with all the audits we have to go through. And every time we have a new auditor, there's always questions and why this is the way we've done it for 20 years. Okay, we'll change it. And so it's an ongoing supervision. This is not a hill for me to die on. I just thought it was something that could be cleaned out. But if it's an issue for somebody, I don't mind just taking it off the list.
If I may respond, that actually alleviates some of my concerns if there is this other process by which, judges are held accountable, then, so if there's safeguards in there, then that alleviates that concern. And for the record, we have never gotten that specific complaint.
Thank you. Any of the other groups want to voice some thoughts on what we should repeal? Do we decide as a group to everybody put their list in writing and aggregate them and see where we meet on that? I don't want to sort of steamroll this, but I do think we need to talk about the data points as well. So for fear of, going Socratic and calling on somebody, Marcy, what did your group have to say about repeal or anything else?
Well, I see that Professor Hanan has her hand raised.
Oh, I missed it. Sorry. Okay, well, Professor, sorry.
Yeah, that's fine. I would defer to Marcy too if she wanted to speak first, but since she was just called upon, I'll go ahead. So our group, we do, we're almost completed with our memo here to the group, but we just didn't get it quite finalized before the meeting. We met, and I think as the advocacy, defense, and academic group, we have a slightly different order of priorities because we're less worried about misdemeanors that are never used and more worried about misdemeanors that have a high impact and might impact working class people in ways that don't improve public safety and at the same time may actually harm public safety by interfering with their ability to get jobs, get housing, take care of their families and so forth. So we were more interested in a framework and honestly concerned that what would come out of this would just be a list of unused, kind of like a cleaning out the junk drawer approach where we get rid of statutes, but they doesn't really change the meter for anybody because they're not used anyway. And so in that, we began to talk, and again, I think we can circulate this by the end of the day, but whether we might need a couple more categories in misdemeanors, and we wondered if the group could consider that. So I looked at Colorado, actually I looked at all 50 states. Colorado wasn't necessarily the best, but it was the one that had changed their system more recently, had some reforms. But the idea would be that if there was at least one other category, like petty offenses carrying no more than 10 days or up to $300 in jail, that's Colorado, a few other, then some misdemeanors, which might be high impact, could be separated out from those that carry up to 6 months. They're high impact on people's lives, but maybe we don't consider them to be as serious. An example of that might be something like And again, if we just established categories, and then we'd have to go through and look at the misdemeanors and see what fit where, which took Colorado, as I understand it, more than a year I think, to do. But so say like first offense trespassing, maybe that's a petty offense. It's not the same level as a first assault on someone, which we would think of as more of a 6-month, standard misdemeanor. So then the second step, if we agreed on categories that we could recommend, would be to identify some of those issues that are of concern for us, whether it's fines or fees or the disruption of jail terms or unevenness among jurisdictions, where maybe a rural jurisdiction or a municipal court tends to sentence people much more harshly than another. What should it be? And is there a role for the legislature in putting any guardrails in areas where there's high variability and therefore a perception of unfairness or actual unfairness? That's just an example. And of course, in that process, there might be some things that are ratcheted up too. Something might be, well, I don't know why this is considered to be such a low-level crime. It might be considered, if you look at them all together, to be more serious. And so part of this process then, and I'll let my group, I'm looking at my memo, but I'm also looking at the notes on my memo, would be to also understand some data around how these misdemeanors are having different impact on different communities by zip code or different by county or municipality, to understand where there might be problems or impact that is unintentional or impact that could, so that there's narrow tailoring to public safety. However, this committee ends up coming out thinking about public safety without any of those byproducts, which can be so harmful to people, like when they're saddled with fines that prevent them from being able to enroll kids in summer camps or get apartments and so forth, for no reason that would really help public safety. So I know that's quite ambitious, but I think our memo could propose 1 or 2 levels of categories, like a lower level misdemeanor and a petty offense. And I would love it if we could talk about that either now or maybe it makes sense at the next meeting. And so perhaps then what happens before this legislative session would be more of a proposal of that with a longer runway to think about the categories for offenses. And that would put us more in line with reform, not only reform movements, but many other states who fine grain a little bit more among misdemeanors.
And if I may, I love the idea of categories. I think that, the fact that the max penalty for, first or second, aside from the statutory specific penalties, theoretically, the max penalty for, first or second DV is 6 months and $1,000, as is when, Judge Higgins fails to disperse the riotous assembly. So, and to me, that's always been troubling, is that we've got misdemeanors, gross misdemeanors, and felonies. Felonies are categorized. That makes sense. Is that the approach we want to take to misdemeanors? And then obviously we could talk about how many categories, what the categories should be, and the penalties and all those specifics. But I'd really love to hear from the group if people are on board with the idea of taking a look at doing a categorization, doing those petty offenses. A thought I have is that lends itself to sort of arrestability as well. If that's a term, if that's a word, I don't know if that's a word, but are some of those petty offenses citation only, that kind of discussion? So I'd love to hear from the group, particularly maybe our prosecutorial folks on thoughts on that categorization or anything there.
And may I add, just this is Eve Hanan for the record again, because I don't need to say that now that we're on Zoom, but add just one more footnote on that, which is that Colorado did reduce the number of categories of misdemeanors. So it isn't better, isn't always more. I'm more suggesting like 1 or 2, or some serious consideration about moving some things to civil infraction. So, like as we did with some traffic in the last session or 2 sessions ago.
I just want to chime in real quickly and say that is a debacle that I cannot even begin to tell you how bad that is. So I have PTSD still about trying to get the civil infraction traffic functional with people trying to negotiate criminal to civil infractions.
Yeah, and that anecdotally, I've heard that as well, that people want to come into criminal, but you can't just magic a criminal offense into a civil infraction.
Yeah, the infrastructure wasn't there. I think in some other jurisdictions where they did that, there was a whole plan for, with unified court systems, it can be easier to roll that out. But without the resources, I think it's been really difficult. And oftentimes there's some civil and some criminal in the same ticket, which really confuses things too.
Right, and that's actually a statutory option, if I recall, that the officer can choose to file on one citation or do multiple citations, so. Sorry, we got things in the chat I'm not paying attention to here.
I was just noting that even a year later, civil infractions are still a total mess.
Okay, and yeah, Ms. Jones Brady also put in the chat about the special grand jury thing in Douglas County that I think was problematic. It was during sort of the height of the protests regarding the murder of George Floyd. So again, that's another one. But like, I guess, and my concern is I don't want to just make everybody meet so we sit here and look at each other. But at the same time, I also have no desire to enforce this is what we're going to do. But I do like the professor's idea and her group's idea of creating those categories, whatever the categories may be. And I think that's the discussion we have. And then attempting to sort of parse some of the offenses in there. And I think that also then lends itself to, are there misdemeanors that were misdemeanors when the statute was passed that now, as a society, I think we find to be more sort of offensive or repugnant, and should those be increased as well? And then I think, to me, fines and fees is such a big thing, kind of like this whole thing, like to take that on. Is that a way to then begin addressing that by having, more specific or statutory options for the sentence when someone is convicted of a misdemeanor? And, like the professor said, less than 10 days and a $300 fine, and how do we look at those jail time issues and all that? So, I see people shaking their heads like, do we want to look at creating those categories of, do we want to take a serious look as this group at creating categories of misdemeanors? Is that one thing we start? And then, because I think we can do that in a parallel track with looking at some of the data, because I think if we come up with a framework for saying, whatever they are, ABC misdemeanor, I'll just use that because it's easier to talk about. If we come up with a framework that we want, that as a group, we think we should recommend having Class A misto, Class B misto, Class C misto. A Class C misdemeanor, is one of those petty offenses. Is there a civil option under it? But is that a framework that this group wants to work on to maybe bring a little bit more order or that? And then in recommending that, that then hopefully would engage the legislature in an idea on some of that and some of those punishments and everything like that. And I think we could begin to, and if we want to have a subcommittee or working group or whatever, I think they're called working groups in SB 123. Lisa would know what they're actually called, but I'm pretty sure they're working groups in the statute.
Working groups.
Okay, see, George, okay, good. I didn't make it up. I always feel better when I don't make it up. So, I mean, we could certainly do that if we want to start looking at that framework, if we want to look at the Colorado structure and that. And then the question, I suppose, becomes, if we come up with the framework and want to recommend it, does this group go through the list and recommend categorization? And I see Dr. Lannerman kind of giving me a head nod, so that may be it. But is that sort of one of the outcomes of this, is that we as a group, decide to take a hard look at creating a multi-tiered, for lack of a better term, classification structure. Lisa?
I support the idea of creating the framework, as you mentioned, parallel with collecting the data. I think once we have the framework in place and we all agree upon that, that'll just make it a little bit easier and a great place for us to start. And also, I know you mentioned some of the data points. I have some suggestions for data points that we had come up with, and I can share them with the group. I can share them here. I could send them in an email. They're certainly not comprehensive or exhaustive. And I think there are, as we go through and collect data, we're probably going to find other data points that we should be collecting also. But first of all, I think we're going to need like 3 different types of data. This is just some of the notes that I had from previous discussions. Court data by jurisdiction, prosecutorial data, jail data, and then again, law enforcement data. And I think I mentioned that on one of our subcommittee meetings before. Jail data, what's charged, adjudicated, fines or fees assessed. I think that's pretty standard. For jail data, things like when they came in, when they were released, court dates, conditions of release, if they're on supervision or any programs or anything like that, law enforcement data, when they might have been arrested, how many arrests they had, neighborhoods, zip codes, some of those things. And again, that's not an exhaustive list. I think it's just a good place for us to start thinking about the kinds of data that we need. And I can certainly send that out to the group as well, so that we all can have something to look at and can add notes or add data or add other ideas to that.
Marcy?
Thank you. And just to add to what Lisa said, I would ask if we could also kind of notify or mark whether there's a Department of Alternative Sentencing in the jurisdiction where this data is being collected. Because I think it would be interesting to see if we're seeing differences or disparities in sentences based on whether there's an alternative sentencing department, and also tracking the number of contempt convictions in areas where there is an alternative sentencing versus areas where there's not. Again, just my limited experience in the rurals is if there's not an alternative sentencing and you violate the conditions of your probation, you're found guilty of contempt. If there is an alternative sentencing, then they just generally modify your sentence or have you serve part of it. So I think it'd be interesting to also track the number of contempt convictions in some of these areas to see if that's the process for imposing conditions of suspended sentences.
Thanks. Now, being that Nevada Department of Sentencing Policy, I'm looking in your direction, you guys are going to be the ones who are the boots on the ground trying to collect the data. I'm thinking on some of that, do we, maybe I'm getting ahead of myself, do we need to do a snapshot, a snapshot in time that this is what happened rather than a longitudinal tracking or any of that? But I think, once we kind of establish some of that data, and perhaps there are charges that we're more interested in than other charges. And again, I don't know, but yeah, I think, and I was talking to one of our marshals earlier, and he said, oh yeah, best way to eat an elephant, bite by bite. And I think that's the situation we're sort of in with misdemeanors, because it's such a monolith and it hasn't been looked at for, we got a lot of stuff from, here's one, 1883. So, like we've got more than 100 years worth of stuff to go through here, which makes it difficult. And everybody else actually has, I think most people on here probably have another job that they're supposed to do on occasion. But like, again, I just would like us sort of as a group, and if we need to take a vote or whatever, to come up with the idea, do we want to, if we want to do let's figure out the framework for multi-level classification, that's one action item for us to move forward with. And then refining the data and getting those points to NBSP So they can do a review and say, yes, we can do this now. No, we need extra help later to do this. How that all works, are those two parallel tracks that, we want to be on right now, I think. And then, as far as the list of what to repeal and all of that stuff, I think we can circulate that and see what matches and everything here. But I'd be interested in hearing from Wes and Nick as far as like public safety red line misdemeanors, if that makes sense, like some of those that are really maybe crucial in from that viewpoint as far as public safety. Like, is that something we set those to the side and deal with this? Like, again, I really don't have a preconceived notion about how we should do this, and we aren't sort of trying to eat an elephant. So that would be my suggestion, at least for discussion, as we determine, okay, we're going to work on data, get that list, work with NDSP to make sure the data is collectible, what we can do, how we can do it, how we can review it, and then also at the same time, if everybody's on board with looking at, a tiered structure of misdemeanors. So. Anyway. So, I mean, I certainly support the idea of creating a framework. Perhaps I'll ask it this way. Does anybody think that that is a bad idea?
No, I think it's a good idea, John.
Good, thanks. Well, if no, oh, Judge Cruz.
So the only, I don't have, like, I like a lot of the forward thinking that we're all talking about, and I think this was the first bite of the elephant that some of our lists were. And I like the discussion about getting the data points and looking. But my only concern, and I'm sure Judge Higgins would chime in on it because we do sit on some of these legislative committees, is that we could, being judges, we could end up in a little bit of a difficult situation as sitting on a committee that's promoting things that historically judges are not taking positions on. We might have concerns, but we don't take positions on regarding, reclassifying, declassifying, increasing penalties, decreasing penalties. Like historically on a lot of these bills, the bench as a whole has not taken a position. And I just want to throw that out there that you could have three judges that were kind of being put in a very difficult position, especially with, not that I'm saying that I don't think this is something that shouldn't be looked at, but there are things that are kind of being advanced that could put us in an unfortunate situation that we're kind of quasi going back and re-looking and kind of passing judgment as to what other judges may have done. And I'm just a little worried about that. I still think that this is definitely, I'd like to see the data points. I'd like to see where it goes. And I think that this committee could end up having some of these recommendations. You just might end up in a situation, depending on where it's going, that some of the judges might have to bow out just to try to stay where legislatively we've always kind of been, if that makes sense. I know you've been involved with a lot of these discussions, John, and kind of where statewide where the judiciary has been on some of these types of issues.
Yeah, and I certainly understand that, and I get that it puts you in a weird position as being the finder of fact to then go back and mess with the facts you're finding, for lack of a better term. So certainly, that's a very valid concern. If we, end up getting to the point where we're making recommendations and voting and those kind of things, clearly, and this, judicial officers could abstain from that vote in order to maintain that, but I don't think that we can do the process necessarily without getting your input. And I understand it's a very fine line to walk. But I think being cognizant of it, we can all try to make sure that we don't get sideways anyway there. But so, and that's what Dr. Landerman just put in the chat, what more succinctly than my rambling, but So, on that, but I think it would be, and in my mind, I think the difference is, the judges, we don't want to put the judges in the position of saying that this misdemeanor is a cat A, this misdemeanor is a cat B, and this one's a C. But I think it's very important to get the judicial perspective on what that framework is, like A, B, and C, petty, how we do that because they're the ones that are obviously going to be encountering that and processing cases and handling those different levels. So to me, that's kind of where I see the dividing line there, is they don't have to vote to make 199, 270 refusal to assist an officer in making an arrest. They don't have to say that that is a category A misdemeanor, but we still get their input on cat A, cat B, cat C, however we do it. Again, I'm just doing that because we're familiar with that because that's Nevada's felony structure. But I think, hearing no objection, we want to come up with a classification framework that we can start talking about. And I don't know if we want to do that in a group here today. Do we want to appoint a working group? Do we want multiple working groups? How do we want to begin looking at sort of that structure? Then at the same time, we're refining the data points. So Georgia and her team can collect, and we can also, talk about who to talk to here for this data and that kind of stuff, because this group has a ton of experience and connections that may make it actually easier to try to find that data or to try to find that data. So, I mean, if the group is comfortable with those two things being what we're working on now, that's pretty terrific. And I'd love to hear, do we want like a working group to come up with a proposed structure, or to piggyback off the professor's 50-state survey? Like, again, everybody has a lot to do, and I don't want to volunteer people to do stuff.
I'm not raising my hand to volunteer. Oh, I'm sorry, Judge Bishop there. I see you
Go
got
ahead,
your hand
Professor.
up. I just wanted to say I don't have a written up 50. I did the research, but I could I think our working group has about a 2-pager on this that we
Awesome.
could share. And then perhaps at our next meeting we could decide where to go from there. And I guess one thing that subcommittee could decide is we'd like more research into all the different possible structures, or we could say intuitively it seems right to have one more level or 2 more levels. We'll leave it at that, but so that we can classify things a little bit more precisely. So we could do that, and I think we could have that by the end of the week for the subcommittee.
Judge Bishop?
I was just gonna note, I like the idea of the working group, because then it kind of leaves Judge Higgins and Judge Cruz and myself out of some of the nuts and bolts thing, but then it's still brought back to us to say, you know what, if you pull this thread, it's gonna unravel over here on us and make a mess over here, and something you might not have thought about because you don't see the interconnectedness of, especially in a little jurisdiction like mine, where everything's connected.
Sounds great. Do we have classification working group volunteers? Or do we want to wait for our advocacy public defense academia group to provide that memo to the group and then have that discussion after and nominate people? I mean, I think if we're looking at like coming up with a recommendation for a classification framework, I think necessarily we'll have to include sort of all the different perspectives represented on the committee. And so I mean, that would certainly be that. So I mean, is the will of the group to wait for that memo to appoint the working group now? Again, I know this is a lot. It is eating that elephant. So again, I don't tend to want to push people to do things that they can't fit in. But I think, and I don't know that we would need like an official motion and a vote either. But if the group is comfortable with coming up with that framework for classification, then we start on that. And then at the same time, we start the data collection. And Lisa, you had your hand up.
John, I was just going to say, I think a great place to start with this is to let our group submit the memo that we've written and let everybody look at it. And whoever wants to serve on the subcommittee, the classification subcommittee, can look at it and say, I think I can help with this. And then we submit that to you. And then at the next meeting, we'll probably have some names of folks who said yes and go from there.
That sounds like a great idea if that works for everybody. I think we do that. And then I know all the groups had the data requests. If you want to perhaps articulate those in a written format, and Georgia, please yell at me if I'm off base here. If we want to sort of articulate our data wish list from the various subcommittees, and then we get that to NDSP, Georgia and her team can look at it, and perhaps this is even another tiering. You know, data we can get tomorrow, data that we'll have to reach out to people and ask them to get, other data, you know, so if that would be a good way to move forward in looking at the data requests is working on that, is getting all the wish list of data together to Georgia and her team, so then they can evaluate it and say realistically what we can do. Because, you know, if we do end up wanting to look at, like, you know, individual level case sentencing decisions, you know, that will take more work on the part of the court to review some of that than that aggregate stuff, just for an example, because, you know, court data is something I'm more familiar with. So I think, you know, if everybody we're good with waiting for that memo, everybody will review it. For the next meeting, we'll have some more sort of concrete suggestions and things to look at. So perhaps we have that come up, create the framework working group. That's going to be a tough one to say. Create that working group at the next meeting, and then also, you know, everybody get your data wish list to NDSP, and they can start classifying that and working on that, so we get a better idea of the time, effort, etc., that will take to collect the data, so we can get what we can get and then work on getting what's going to take more, in that fashion. If those are both reasonable proposals, I think that's a good way to go. Again, we can get the memo. I can probably leverage some resources around here to have people look at misdemeanor structures in some other states as well. So we can get that information for the next meeting and then appoint the working group. And then at the same time, we'll be working on the data wish list. So if our various working groups could get, you know, what data points you want to see to NDSP here in the next, what would you say, 2 weeks, week, Georgia?
I would say, yeah, 10 days to 2 weeks would be great for us.
Yeah, so if we could get our data wish list to NDSP, let's say by August 7th, or you want to say August 9th?
I would say, let me look real quick. The 9th would be fine.
All right, so if everybody could have their data wish lists to NDSP by the 9th, that would be great, from those groups. Then they can do that, work on that, and then, well, like I said, I'll just keep repeating myself until I shut up. But then at the next meeting, we'll come back and really look at the classification structure and look at the data, and then that'll kind of push the group, you know, push this group forward. Is that agreeable to everybody? Anybody disagree? Think that's the worst idea ever? All right. Well, if that's, you know, I think that's a good way forward, particularly trying to eat this elephant. And, you know, everybody does need to tell Judge Higgins that he was volunteered to do all the work. So, because he had to go back to court. So, if the group is cool with those two being our path forward, I think that's a good idea. And, yeah, anybody have anything else that they would like to discuss, raise at this point, or if we're comfortable moving forward in that manner, we can certainly do it. And on the misdemeanors for possible deletion, if the groups have their lists, I mean, and if you didn't make a list, that's fine, but I'm gonna go through and like cross-reference mine and the judges. And Lisa, comment?
Of course, I have one more thing. One of the concerns that came up in our working group was what data points that we have access to.
Mhm.
And if there's a possibility that we may need some legislation to say to the agencies that we're requesting data from, that you have to get this data, or does the NDSP already have you been empowered to collect all of those things? So I think when we get those data points to you, look at them and see if there's anything on there that we might need help from the legislature with getting, or saying to the legislature that you have to telling the agencies you have to provide this data. Because I can tell you, as asking for data, we run into some issues with getting data. And so I'm wondering if just what we are empowered to actually collect through the NDSP, and what we might need some support from the legislature on, if there is anything.
And I think also on that is, as we're discussing, look at the data and do we need the legislature to help us? I think an important part, and at least this is just purely my opinion, sometimes the ability of the local agencies that possess the data is, resource wise, they don't have the resources to spend the time to do the data. So how do we begin potentially to address that situation as well? And obviously it's not a one meeting, one session kind of thing, but I think that if we're cognizant of that, we may have better success asking for additional data if we try to take into account and help folks work with that. But again, that's just my sort of 2 cents there.
No, totally agreed. And I think at the end of this, when we make our recommendations, our final recommendations, that may be one of them. Like, we need upgraded systems. Agencies need to be able to collect this data, and resources need to be provided to those agencies so that they are able to collect this data. So that could be one of our final recommendations that comes out of the subcommittee.
Thank you. Anybody else have final thoughts? We might actually keep this to an hour. Oh, Georgia, sorry, had your hand up. I wasn't.
No, that's fine. I just wanted to thank Lisa for that. I mean, as the data collecting agency, we have struggled with this all along. We are not considered a criminal justice agency. And so there are some pieces of data we cannot get and we haven't been able to get. The other struggle is what John was saying, is that a lot of agencies who we would collect data from are working with antiquated systems that are 20 plus years old. And so even though the data is there, it's very difficult to pull and then to compile with somebody else's 25-year-old data. So that's the struggle we've been having. And we have been looking to ask the legislature to help us with that situation, whether it be giving money so we can have a more easily universal system for everybody, or to make us a criminal justice agency so that we have access to everything we need. So I just appreciate you bringing that up.
And Georgia, you and I talk about making you guys criminal justice agency offline. I had just fired up some ideas in my feeble brain. Anyway, so unless anybody has anything else, we have a course of action, and I certainly appreciate you spending a Wednesday afternoon with us. So that would bring us to agenda item 5, which is future meetings, which is sort of what we've been talking about here. And I think we have our marching orders, and I'm certainly happy to serve as a hub for any of that, or ask my team to assist. Our next meeting will be September 11th. So that gives us a month and a half to get all this together, and then we can proceed there. Does anybody have anything else that the group that you think this group should be looking at that we haven't discussed looking at? That's what I'm trying to say. And obviously you don't have to answer now. If you do come up with something, shoot me an email or NDSP or something on that. But I think, that classification framework will help us move forward. So if nobody has suggestions or ideas for future meetings, and of course we can do that offline, we'll move to agenda item number 6, which is our second period of public comment. And just as we did in the first period, those who wish to testify may do so by telephone. Due to time constraints, it may be limited to 2 minutes. Any member of the public that exceeds the 2-minute limit may submit their testimony in writing to the Department of Sentencing Policy. At this time, I would ask Ms. Jones to let us know if we have anyone who wishes to provide public comment.
Looks like no one wants to provide public comment.
All right, thank you. With that, I will close agenda item 6 and we'll move on to agenda item 7, which is adjournment, and have 2 minutes back. I was going to try to keep this to an hour. We made 58 minutes. So thanks, everybody. Appreciate it. And I promise we'll have to start working a lot harder as a group after the next meeting. Thanks.